This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Ballmer, and today's guest is Gregory Herman-Giddens. He is a trust, estate, and tax attorney and president of the Trust Counsel Law Firm and president of Trust Protector LLC, which provides trust protector services domestically and abroad. Additionally, Mr. Herman-Giddens is a sought-after expert witness, and he specializes in, of course, trust and estate litigation cases. Mr. Herman-Giddens holds a JD from Tulane. Mr. Herman-Giddens, thank you so much for joining me here today at the Roundtable.
Well, thank you. Glad to be here, Noah.
Of course. Let's jump right into it. So you're an established attorney with over 30 years of experience, but I'd like to focus on your expert witness experience. How did you first become involved in expert witnessing?
It's a little fuzzy at this point, but I think it was probably about 20 years ago now, 15 perhaps. A colleague in North Carolina had a trust litigation case where his client was accused of breaching her fiduciary duty. And I think he reached out to me knowing that I was an experienced trust attorney. And I don't know if he reached out to me just for sort of advice or if he reached out to me directly to say, hey, could you be an expert? But in any event, it did come to pass that I was an expert, in this case for the defense, in this breach of fiduciary duty case. It was actually a very interesting case, and I had a less than enviable position to try to defend what this person had done as trustee. I'm usually on the other side, but at this time I represented or was expert for the trustee's attorney and who had been accused of the breach.
That's interesting. You talk about, obviously, there's experts on both sides. What are some of the differences between working for the defendant side and working for the plaintiff side?
Well, I'd say that was probably that first one was the only time I have worked for the defense. So ever since then, I have been expert for the plaintiff, which is usually either a beneficiary or beneficiaries, or someone who has taken over as trustee after the misbehaving trustee is no longer serving in that role. In most of the cases where I've served as expert for the plaintiff, where the trustee has been accused of breaching fiduciary duty, it's quite egregious. So it doesn't necessarily make my job easy, but I don't have to struggle to try to find ways to, I guess, convince the court that there was a breach. Whereas the first matter that I had, I think this was a lay fiduciary, somebody who didn't have any training as a fiduciary, was not an attorney, and I think she did, in fact, I think, breach her fiduciary duty. So what I tried to make it seem like no harm, no foul. That was basically what I did. And interestingly enough, the first hearing, the court found in our favor. So no breach. But then somehow the plaintiff was able to have the matter reheard on some grounds, which I don't recall at this point. And in that case, I testified in that hearing as well. But at that time, it did not go in my client's favor. So she was found to have breached her fiduciary duty because there really wasn't much of a defense. The difference there was that the first time the plaintiff did not have, second time around, they had their own expert. So it wasn't me trying to convince the court in sort of a vacuum that this breach hadn't really occurred, or if it did, there was no harm.
Do you find that a significant portion of the work for an expert witness is rebutting what the other expert witness is saying?
In my experience, no. and I'm not an expert who has done, dozens and dozens and dozens of matters. I've probably in total done about 10.
Mhm.
But usually after I produce a report, or sometimes even after I'm disclosed as the expert, that matter ends up settling.
Okay.
And so I haven't gotten to the point where I've had to see a report of an expert on the other side and trying to, say, well, this is wrong in this way. Now, I do a lot of times pick apart the defense counsel's arguments in the pleadings.
Sure.
Because they might be expert litigators, but they're not expert trust attorneys. And so that's something I do quite a bit is say, well, this defense is not valid because of this or that.
Even though a lot of cases, especially now, are going to settlement, do you always prepare as though the case may go to a jury trial or to a bench trial?
That's a good question. I try to walk a fine line because I'm always cognizant of the fact that, my clients, being the attorneys and ultimately their client who foots the bill, I don't want to run up, tens of thousands of dollars in expert fees if I think it might settle.
Okay.
So I do try, unless I know we've got something, a hearing already scheduled or the trial is scheduled and it doesn't look like it's going to settle. I will typically sort of take it one step at a time.
Is that part of the initial phone call when you are first vetting the attorney and they're vetting you and you're deciding if you're appropriate for the engagement? Is part of that calculus the likelihood that it might settle?
Well, I mean, I would accept a matter potentially either way. I don't know how other experts feel, but I relish the chance to go to court or to be deposed, but I also dread it because, I don't know if you've ever been cross-examined, but it is not a fun experience because you've got an attorney there trying to make you look like a stupid fool. And while you might be able to showcase your expertise, it also can be a very humbling experience and not all that pleasant. That's, I think, why a lot of experts charge more for being deposed and testifying because it can be tough.
Let's dig into that a little bit. What are some of the strategies that experts can employ to, I mean, obviously it's never going to be a happy walk in the park, but to help mitigate some of that anxiety and to be well prepared for the types of questions that they're going to get either in a deposition or in a jury trial?
Preparation. You want to make sure you've done any research necessary and are confident in your opinions. I mean, usually by that time there is a written report that's been prepared. So hopefully, in the process of preparing that written report, you've done a lot of that background work and feel pretty well prepared to be questioned. But it really just like the attorneys who are prosecuting the matter and defending the matter, it's really about preparation and knowing your stuff.
Are there specific preparation techniques that you find are more effective? In other words, something like mock cross-examination. Is that something that you've been involved with?
I have not done that. I've had conversations with the attorney that has employed me and sort of what his or her thoughts are about what sort of lines of questions will come out from the opposing attorney. But I can certainly see where that would be helpful, particularly, of a very high stakes case where it's expected that the cross-examination may take a very long time, might be hours or something like that. I mean, because it's a very tiring experience and it can wear down the best of us to be on the stand for hours. I mean, in the news now, we've heard about Michael Cohen being cross-examined and
Sure.
I don't know if any of that testimony was available to see live, but I could just imagine him, even as an attorney himself, it's like, oh, after hours of being, I just want to crawl away.
Sure. Yeah, absolutely. Yeah, he was absolutely grilled for quite a long time. Yeah, no, there's no cameras in that courtroom, but that's definitely what the press has reported. Let's talk a little bit about how the role has changed. You say that you haven't been an expert witness too many times, but it's been over a good amount of time. Have you seen significant changes in expert witnessing, either in whether they're moving to settlement more or technology is being used, in other words, things like Zoom meetings are being used more, anything like that? Have there been changes that have changed the way that expert witnessing works in general?
In my case, nothing particularly significant, other than now, my first probably couple of expert matters, there was no such thing as attending a hearing remotely, or they had video depositions, but it was unheard of to have a hearing or a trial where everybody wasn't there in the same room.
Sure.
And so I have a case I'm involved in now where the trial was supposed to be in April, but it got continued. And the attorney said, in terms of a few weeks before, whether we needed to start getting ready for the trial and things like that, they said, well, we don't know yet whether this is going to be in person or virtual, or partly in person and partly virtual. So I was like, well, I don't know what I'm going to get. Am I going to be cross-examined through Zoom or something? So that is a bit new. I have not yet had the experience of having to testify remotely, but that probably may come.
Even though you haven't done it remotely, as both an attorney and as an expert witness, how do you feel that could impact kind of just the overall case? Does it make a difference? Does it make a difference to the judge, to the jury, to just that kind of eye contact through a camera? In general, does that make a difference to the way that you would approach the case?
Well, you may be a little less worried about body language and things like that, although some of that can be picked up on video anyway. So
Sure.
I think that's probably more of a concern of the attorneys, trying to figure out how, what's going to make the best impression on the judge, and if there is a jury involved, on the jury. And obviously I would want, as an expert, for my side to prevail, but I don't have quite the stakes involved that the attorney who hired me does.
Sure. When you talk about wanting the case to prevail, obviously an expert witness's duty is to the truth and to the court and to neutrality, whereas the attorney's duty is to their client. How does an expert witness square that? How do you simultaneously do the best job that you can for the person who hired you while maintaining your commitment to neutrality and the truth?
Yeah, that's a good question. And I think, obviously, I don't think anybody could be an expert on trust matters without being an attorney. But
Sure.
my training, nevertheless, my training as an attorney helps me because, we all learn, even if not in practice, but in law school, we're taught you have to be able to argue both sides of the case.
Right.
And you can't misrepresent the facts or the law. You just have to make a creative argument, that that is not a misrepresentation of the facts of the law. It's something that is potentially plausible. It may not be immediately apparent that it could be the case, but you've got to do the best you can, and you do not ever want to misrepresent anything. And that's drilled into us as attorneys. So as an expert witness, it causes me worry sometimes if I feel like I don't have a very strong position. But I'm happy to say I'm never tempted to stretch the boundaries too much. I will love it if I could find a good argument that is not necessarily viewed as being mainstream, but that would help my client. But and that's something I will do, but certainly would always want to stay on the straight and narrow.
Do you feel that attorneys sometimes try and nudge you as an expert a little bit too much one way or the other, or do they pretty much allow you to remain neutral without too much pressure?
Well, if you're talking about the attorney who's hired me as an expert,
Yes.
usually, yeah, I think they will definitely say we would like you to be able to state this,
Sure.
but they would, if it was something that I wasn't comfortable with, I would just push back and say I can't. I'm sorry, that's just not going to work. So, I mean, they usually have ideas about where they'd like you to come out. But I've never had a situation where I felt pressured or I felt that the attorney was getting beyond the bounds of zealous advocacy and trying to make me do something that I wasn't comfortable with.
I've heard from a number of expert witnesses that sometimes they receive a deluge of paperwork and it can be at times overbroad. And as you were saying before, you don't want to charge $1 trillion to read a bunch of irrelevant stuff. How do you separate the proverbial wheat from the chaff when you're deciding what exactly to get ready for and to research and to prepare for prior to writing your expert report or going into a deposition?
It's best if the attorney can point out what the most important documents are to review. And that's particularly in a case when there's just, hundreds of documents. Because one issue on my part would just be that, do I have the time to review all these? And then two, do I want to build a client for all this work? Then some of this stuff is not really necessary for me to review. So in my current case, the attorneys were great. They said, they gave me the list of all the date stamped documents, and they said, I think it's best if you review these, and these. And of course, I looked at all of them.
Sure.
But there were ones I could look at and say, oh, I don't need to spend a bunch of time reviewing this. I'm going to concentrate on the ones that they suggested I spend the most time on. I don't know that I would be comfortable as an expert to just ignore certain documents because the attorney told me that they weren't important. So, I'm going to want to check them all out, but I will rely on the attorney to say, hey, this is most important. And
let's talk about getting paid with contracts with attorneys. Do you typically include any specific language to, let's say, protect you in case the case moves to settlement, but you've done a lot of work? For instance, do you take a retainer? Do you prefer to bill hourly or project rate, or does it vary depending on the case?
It does vary. Sometimes if you're working through an expert clearinghouse, basically they help find experts for folks. They oftentimes don't want you to charge a retainer, and they're the intermediary between the expert and the attorney. So you don't bill the law firm or the attorneys directly. You bill the expert clearinghouse. And so in that case, you just have to be willing to, that you can get a retainer, but they usually don't want it to be non-refundable. And so I will get a retainer, and just knowing that, if I don't use all the retainer and then the case settles or something, then I will refund the rest. My preference is to have a non-refundable retainer, which I do if I'm hired independently, because, witness matters can be very time consuming. And so
Absolutely.
if I accept one, I have to make adjustments in what other matters I might accept in the future. And so that could potentially lead to a loss of income.
Right.
So like I said, that's a preference. Is I say, well, I charge, 5,000, 7,500, whatever it is up front. If you settle the next day or say you don't need me, that's great, but I'm keeping the money. because I may have turned down another matter.
Absolutely. Let's talk a little bit about that kind of work-life balance. As you said, sometimes an expert witness engagement can go for a very long time, much longer than expected in those initial phone calls. How do you manage to maintain a career, in your case as an attorney, while simultaneously having commitments to things that have potentially a long lifespan without knowing how many hours it's going to take? What sorts of issues are there, and how do you deal with them?
Well, I think you have to be willing to put in the time that's necessary, because sometimes attorneys don't give you a lot of leeway. They or headwood, they don't give you a lot of advance notice. They say, "Oh, we need this report, in a week or
Sure.
something like that," which is not ideal. But the last report I did, I spent, I think, at least I feel like a full weekend and several early mornings and nights trying to get it completed. And it was turned in, I think, the morning it was due. Because I'd do a draft and I'd send it to them, and they ask other questions, and of course I had to review all the documents.
Sure.
Uh, so it's a lot of reviewing the document, going back to the report, looking at the pleadings, and it can just take a tremendous amount of time. So I did put in a lot of extra hours in that week or so, just because, again, I had my practice, so I had to do all that work, and then I had to push to get the expert witness report done. So, I'm used to having to do that type of thing, sometimes just with my practice. And I think most attorneys are, but it's not ideal. So, hopefully if you're taking on expert witness matters, you're, making adjustments in your practice to allow you not to have to work a significant amount of extra hours.
Right. Have you worked across different venues? In other words, have you, as an expert witness, worked in state, federal, regulatory, or have you pretty much stayed in one venue?
It's always been state court. Federal courts don't deal with trust issues for the most part,
Okay.
and there's not really administrative hearings on. So it's generally state court. I have served as an expert in several different states.
Okay.
So it doesn't have to be a state where I'm licensed. That might be helpful, but I've been an expert in North Carolina, Florida, Michigan, California.
For an expert witness, what are there considerations that you have to take into account when accepting an engagement that's out of state? Do you have to know something about Florida trust law if you're coming from North Carolina, or is it not so important, or is it just a matter of what your attorney tells you that you need to know?
Well, in my last engagement, I asked them, I said, you probably know because you looked at my background, I'm not licensed in Michigan. Does that make a difference? And they're like, no, this is general principles of fiduciary law. There may be some statutes involved, but, particularly as an attorney, which again, pretty much have to be an attorney to be an expert on trust law. But, I'm comfortable looking at other state statutes and, at least on its face, determining what it means. And most state laws that have to do with trustees and fiduciary duty, and they're pretty similar. So I would say, anybody out there who's wanting to, try to start serving as an expert, don't feel like you have to be limited to your state of licensure.
Let's move to a couple general topics. What is important? What is fulfilling? And what is also just kind of subjectively important about being an expert witness and about just the existence of expert witnesses to you?
I mean, honestly, it's kind of nice to be known as an expert.
Sure.
And I think in my case, it could potentially help my practice as a trust and estate attorney, because I think people looking at it would say, oh, well, this guy probably knows his stuff because he's, serving as an expert in litigation involving trusts and estates.
Sure.
And so it's a little bit of an ego boost. You can have that hammered down by opposing counsel sometimes, but and then there's interesting issues involved in a lot of these cases too. A lot of them are family issues where you've had a family trustee either steal money or invest in an incredibly poor way. Sometimes you have a corporate trustee who's done something wrong. I've had attorneys, with big firms. A lot of times you think all these big nationwide firms that they can do no wrong, but that's not true. I mean, there's attorneys in these firms who they charge their clients a lot of money, but they end up colossally screwing things up on a fiduciary basis as well as just a legal malpractice basis. So it's nice from that standpoint. It's interesting work, and I think you can feel like, at least like me, if you're usually on the good side, you feel like you're helping out these parties that were wrong.
Absolutely.
But if you're not if you're on the so-called bad side, it can be very interesting and intellectually challenging to try to defend against, these accusations and allegations. So while I haven't done, I've only essentially done that in this one case, that was interesting, and that to try to, think of some arguments that would help my fiduciary.
What makes ultimately a good relationship between an expert and an attorney?
Good and frequent communication. Well, responsiveness is important, because I think, despite the fact that I enjoy working with the attorneys in my current case, sometimes their responses haven't been very timely. And, I think the fact that they're litigators is an excuse, at least to some degree, because, they may very well be in court for days on end.
Sure.
And also having a team, if you have a team of attorneys and or assistants that you can connect with, that helps, because if you're not getting a response from someone, you can reach out to one of the other team members.
Speaking of teams, have you worked on teams that have other expert witnesses, not just a trial team, but multiple expert witnesses for the same matter?
Yes, I have.
What degree do you interact and collaborate with them?
So far, there has essentially been very little of that. And I think, part of that may just be that our issues aren't all that related.
Sure.
Or part of it may be the stage of the case. Now my current matter's on hold. I don't know that the judge is even, I would hope that they don't have a trial date yet, because nobody's told me when the trial date is. But after, here's an example that wasn't less than stellar communication. There was a hearing in April to determine about continuing the trial, and that date came and went, and a couple of weeks went by, and I'd never heard from my team. So I was like, do we have a trial or not? And so finally I had to reach out to them and say, hey, look, what's going on? They said, no, we don't have a trial yet. It's trial date yet. So that's an example from the attorney side. Just keep your expert informed. And I think from the expert side, definitely, if you are getting hung up on either an issue or a timeline, a deadline, to try to make sure you keep your attorneys apprised, because they don't want to get jammed up on, the day before a deadline and know you're not going to have your report ready.
Absolutely. Before we wrap up, do you have any last advice for expert witnesses, and in particular newer expert witnesses?
I would say you just have to decide you want to be an expert. You have to have the experience and credentials, obviously. If you're a year out of law school, you're not going to be an expert witness. But, if you've got a decade or a couple of decades of experience, working in trust and estates, particularly if you have board certification and or an advanced degree, and it's something you think you may want to do, just put yourself out there. Things may come to you. And then, once you get one under your belt, maybe a smaller matter, then, you'll have that one experience as an expert, and you can draw on that the next time. So in my case, I think it's helpful to have drafted trusts, represented trustees, and also served as a trustee myself. So I've done all of those things. So if you have sort of well-rounded background in trust, I think that would be helpful. Now, of course, you don't have it to be my primary area of expertise is breach of fiduciary duty and things like that related to trusts. But even within the trust and estates realm, you don't have to focus on that area. I mean, you could be an expert on the use of powers of attorney, for example. I did have one expert matter that related to a power of attorney.
Oh, good stuff. Well, Mr. Herman-Giddens, thank you so much for joining me here today at the Roundtable.
Well, you're very welcome. I've enjoyed it.
Absolutely. And thank you to our listeners for joining me for another discussion at the Roundtable. Cheers.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.